Hi everybody, Jens Johanson here again today with another video specifically for building owners and any kind of building owner, whether it's condominiums, apartments, commercial. I'll let our guests talk about that today. But in our studio today we have Greg Harper. He is a founding member of the law firm Harper Hayes, and he is a construction attorney and insurance specialist as far as finding money out of the insurance policies. And so he's agreed to come in and talk today about some of these kind of hot topics and kind of sometimes confusing topics of what is construction damage and how do we go about figuring it out. So, Greg, thank you for coming in today.
Hey, thanks for having me.
Absolutely. Tell us a little bit about yourself. You know, where you went to school, what do you do, how do you do it, and then maybe one personal. Maybe it's funny, maybe it's secret. No confessions. We're on air, but
Yeah.
Well, tell us something about yourself.
Well, I grew up in Tampa, Florida. I've been in Seattle over half my life now. I'm a lawyer. My practice emphasizes the representation of property owners, commercial, public owners, private owners, light rail stations, apartments, condominiums, you name it. I've been doing this for about 18 years. My law partner Todd Hayes and I have what I would consider a boutique firm in downtown Seattle. Our typical client, Jens, is a property owner who, 15 years ago would have found themselves, although they try to avoid it, found themselves in construction disputes that happen to involve insurance. Over the last 15 years, it seems that our practice is emphasizing helping clients who are involved in insurance disputes that happen to involve construction. But we help building owners of all species and varieties.
Gotcha. So, a little bit, what do you like to do in your off time when you're not being a lawyer?
Well, in my off time, I guess I can best talk about it in relationship to I put it this way, my wife has banned me from entering the Outdoor Emporium outdoor store. I have a little bit of a fishing avocation. My family and I like to be on the water, so that's what I try to do when I'm not engaged in my profession.
But after the Cabela visa bills and Outdoor Emporium big statements.
Yes, as a lawyer, I'm a strict constructionist. I've been banned from the Outdoor Emporium, but that doesn't necessarily apply to other places. So I'm gonna outsmart the ban.
Good, excellent. All right. Well, so as a construction consultant, when I'm talking to people and introduce myself and say, hey, I'm a construction consultant or I'm a construction defect consultant, I get this kind of blank stare, the eyes roll in the back of their head. They're trying to place me as an architect or an engineer, or even worse, I say I'm a building envelope consultant, and they go, Manila, big 9x12 letter, I don't get it. So let's start out with what's your definition of construction damage or construction defect, or what is the angle of what we're talking about today?
Well, I can answer that in the context of my practice. So our typical client is a property owner who is dealing with some type of unforeseen issue at the building or property he owns. In Seattle, it's often related to water damage, but we've had cases that involve all types of problems in buildings or construction where the owner typically comes to us and says, our question is this: we've got this problem, we did not create it, it's not our fault. Is there any other party that is legally obligated to pay for this? Because obviously the bottom line and financial concerns of our clients are paramount. So the question is often posed, how do I deal with an issue related to construction? Lots of it relates to water damage, but not necessarily all of it.
Okay. Do they have to be new? Do they have to be less than 5 years old? Does it have to be a certain time frame on this?
No. Property owners of all species and ages of property, a wise owner would be aware of the various rights out there that would entitle them to seek compensation and make some large repairs from someone other than themselves. Typically, all property owners perhaps have rights under three general varieties of things. Number one, there's contracts.
Okay.
Real estate purchase and sale agreements may give property owners rights.
Gotcha.
Leases may give property owners rights. Hold harmless agreements may give property owners rights. Construction or architectural contractors may give property owners rights. And, often overlooked, Insurance contracts are another type of contract that many property owners never think about as a potential avenue to gain funding to make an unanticipated or unforeseen repair.
So you call it a different word, and I'm going to clarify. You call it an insurance contract. How do I get an insurance contract?
Insurance policy. Insurance policy. Liability property insurance policy. So there's contracts.
Right.
There's state laws or statutes that you can find in the RCWs that give rights. RCW 6434 is the Condominium Act.
Washington law.
Washington law. RCW 6450 is a special law that applies to construction defect actions in Washington.
Okay.
There's RCW 19.86, which is the Consumer Protection Act, which gives property owners rights in certain situations. And last but not least, Jens, there is RCW 4830, which is the Insurance Fair Conduct Act, which is a statute that protects property owners in relations with insurance companies.
Now you just listed off a bunch of Washington laws for some of our viewers in other states. Is it fairly typical that other states have similar things? I mean, we don't know the exact numbers, but if I'm in Michigan, would I have kind of a similar standard of law, or is that something very easily checked on, or regardless of state?
No matter what state or jurisdiction you're in, there would be state laws and regulations that likely apply to protect insurance consumers. Now, there's going to be, nuances in those laws. There's going to be different ways the courts have interpreted those laws, but there will always be a statutory or regulatory set of protections for property owners.
Okay, so one of the melodies that I'm preaching is what you've just talked about is very specific understanding of your state law, and so the importance of a specifically trained lawyer to get that. Can you give us a little bit of that? Most commercial owner, yeah, I've got my lawyer reviews my contracts, he does that stuff. Condo owner, yeah, our HOA lawyer writes the tickets for the cars parked illegally and the dog poop on the lawn. And can you tell us a little bit about your specialty and how that's different and why it's important?
Yes, our emphasis, as I mentioned, typically is when a property owner has a problem and is seeking advice on whether there are any other parties legally obligated to pay for this. So, I mentioned 2 of 3. There's also, common law or judge-made rights, warranty of habitability, tort of bad faith in the insurance context. But generally speaking, a property owner will ask me as a lawyer, can you give me some advice or an opinion on, am I on the hook for this, or are there other avenues of recovery, which then would require, I believe, a competent lawyer would know to look at those 3 sources to see if any apply to this property owner, and if there's a viable, cost-effective, positive effort that can be made, the lawyer should advise in that regard. And in fact, if there's nothing there, I think good advice would be it's not worth your time.
Okay. So I'm even digging a little bit further, because sometimes we talk to our clients and they go, oh yeah, sure, I got a lawyer. I'll ask him. And they'll come back, oh, they said there was no coverage. I'm like, wait a second. Yeah, you may have a lawyer, but they don't get it. And so what niche do you come in at? I mean, so when I tell my customers, for instance, you need a construction defect or an insurance understanding lawyer that gets this.
Yeah.
So how do you market that? How do you distinguish yourself?
Our market, and I think the way we've distinguished ourselves, is that we've got many years of experience in representing policyholders in insurance disputes that happen to involve construction. So property insurance, liability insurance, directors and officers insurance, builder's risk or course of construction insurance. When those type of policies are at play, we've had a lot of experience helping our clients find the coverage that exists. And coverage is not a black or a white, it's a gray. Right. All insurance policies are subject to interpretation, oftentimes self-servingly. And I think courts have interpreted insurance policies in Washington that may be somewhat counterintuitive to folks. So if there are issues, we've been able to step in and help with the insurance expertise. When property owners have a dispute that may be covered by insurance, I think that's when the call should be made to us or lawyers like us.
Right. Tell me a couple of the myths that you deal with, and what I mean is, so we're advising our customers, and they say, well, my brother-in-law works for a law firm, and he said, my manager said, my we talked about my attorney said, my business attorney said, or somebody. What are some of these myths that you hear or that you fight against, and you say, I wish that was just clearer, and I wish. So the point of this video, how do we make these things just perfectly clear that these are myths?
Well, yeah, an example of a large and pervasive myth is when there is a loss, whether it be damage by water, damage by some type of event during construction, fire, unforeseen windstorm, there's a tendency to think that unless a party was at fault, like in a construction defect dispute, there is no avenue of recovery. That is not necessarily always true. Property insurance, builder's risk insurance, covers damage that occurs during a particular policy period. So property insurance in Washington can, policies in the past can apply to a loss that, while it's only found or manifested itself today, if it had happened years ago but was hidden, like in a water damage claim, there might be policies that had been purchased with effective dates that were before the current period that should be looked at. So misunderstanding of the availability of property insurance is one big myth. A lot of folks don't believe it applies. A lot of folks only believe you look at the current policy. Not true. So that's a myth. Another myth is, for example, we've represented several contractors, large and small. Sometimes they face lawsuits and their insurance companies aren't giving them the support. Sometimes they're not paying for the defense. Sometimes they're not paying a settlement or judgment. And a lot of times the contractor won't take a deeper look because they heard from a broker or a friend or another lawyer, hey, that's never covered.
Right.
Never is an absolute. It always merits a look, I would say.
Right.
And I think that is where we can gain some traction for our clients, is to give an educated look and let you know, is there or is there not a viable avenue for recovery? A lot of it relates to insurance.
Okay. So you brought up a couple things in that. So what does it take, I guess the first question, what does it take to have you take a look? What does that mean? What are you looking at? What are you looking for? Is that tons and tons of hours, or is that just a quick look-see, or what is that?
Well, the way you unravel or unwind any of these particular insurance issues that happen to involve construction is you talk to the client, you get an understanding of the facts, you ask the client for such things that we talked about. Are there any contracts that might apply? Are there any insurance policies that we need to look at? Are there any facts that would, give rise to protection under some state law or statute? So, I think, my view is an initial discussion, which folks are always happy to call us, and we're happy to give you our take. If it looks like there are facts that merit a more in-depth look, it depends on what exactly we're looking at, but we're pretty efficient. We're always happy to take a look. We would ask for underlying facts, contracts, statutes, insurance policies, and we typically go from there.
Okay. So in a mindset of, saving our taxes or saving our documents, we kind of get this mindset of, hey, you got to save things for 3 years or 5 years or 7 years. What a theme I hear you saying is save those insurance policies forever. Yes,
that's
okay.
That's advice, and I've lost count of the number of clients who have had successful efforts with relation to getting insurance recovery that they never would have thought to have even made a claim, and they were gaining coverage and recovery under policies that they had long thought had expired. Not true.
Wow.
Save your insurance. Yeah. It's easy to scan those things these days.
Yeah,
go paperless.
Dropbox,
put them on the cloud.
Yeah.
Put them on Dropbox. Save them. They may come in handy if there's a loss at a later date.
What's the oldest one you've seen?
We've had cases, for example, we had helped the Condominium Association in probably 2011. In doing some repairs, they found some water damage that had been hidden before that. And it took a lawsuit. It took an order from a federal judge, but there was determined to have been coverage under policies from the early 1990s.
Wow.
To pay for a loss in a condominium that was discovered in the late 2000s. That's a pretty typical story, Jens.
And that's great. That's great. So let's see. We talked about contract stuff. I'm going to check my notes here. We talked about state laws, insurance policies. you know, we talked a little bit about the use of construction. Well, I don't think we talked about it. The use of construction professionals, or how what's kind of a next step. So you guys have looked at the policies. You say, hey, I think we might have something here. Then what do we do? What's the next
Well,
step
you
in
know,
this process?
a lot of times when clients contact us, they've already had, they're working with construction professionals, they're working with building envelope specialists to try to understand the nature and extent of the problem and to put together what I call a recipe to find the problem and to fix it so it
Gotcha.
never happens again. So a lot of times that team is already in place when we get involved. But, you know, in retrospect, I think the best way for property owners of any variety to work with construction professionals like J2 is to make sure everyone understands what's the purpose of the investigation. Obviously, to identify and find all of the deficiencies and damage that need repair, but also it's to gain evidence which might be useful in a later claim or dispute with an insurance company or another party. So in that respect, we've always counseled that early on in the process, the building owner, the construction professional, and the lawyer meet to make sure that there's a critical path, that there's a plan that serves all
Right.
purposes, and that things like important evidence get preserved, get documented in such a fashion so if there is a need to make a claim, if it turns out there's a dispute with an insurance company, everything's prepared. And so in my view, that's one of the things that if I were a building owner, I would look for
Okay.
in a building envelope or construction professional is the ability to see the whole picture and be there to serve the owner in whatever capacity, consultation on site, perhaps expert witness work in a courtroom or a court of law to testify about what they saw, what it meant, what their opinion is, and how it needs to be correctly repaired.
Okay, so that's working the process from problem to resolution, let's say, and both you and I have been involved in projects where we will do the job and then come back and with a pile of receipts and ask for reimbursement. What's your thoughts on that?
You know, for example, in a case where a property insurer has coverage or might have coverage, there are obligations in the insurance policy that require the insurance company to do certain things and require the policyholder to do certain things. One of those things is to give prompt notice of any potential claim. So I always advise that prompt notice be given. Property insurance policies also have built-in statutes of limitation that require lawsuits to be filed within a specified period of time if there's ever a dispute. So prompt notice, being aware of what the policy requires, obviously giving an insurance company or another party the opportunity to see the evidence, to understand what's going on, so you hopefully can work the dispute out is important. So to the extent possible, to get back to your question, I would advise that you make claims or engage insurance companies or other parties early in the process before the repair has been completed,
Okay.
because it has a tendency to yield better results, but certainly there's no hard and fast rule. We've helped clients who've come to us, frankly, after a construction project had already been done and asked whether we could help them gain recovery from a responsible party or an insurance company. And under the appropriate circumstances, we've been able to do that, but it tends to be a bit more challenging.
Gotcha. So do it up front.
Do it early
Yeah.
and do it up front.
Okay. The you mentioned statute of limitations for once I know about a problem on my building. Is there a typical timeline? Does it vary by policy? Does it vary by state law? What is that timeline?
Every state has different law, but
Okay.
generally speaking, one of the most important pieces of advice we give to clients or prospective clients or just folks we're talking to in the field is this. If you believe there's a problem that you are not responsible for, be aware of limitations imposed by law or by a contract. Every state has a statute of limitations, which means a specified period of time with which you have to file a lawsuit against a party who you think is responsible for causing injury or damage. It can vary depending on what type of claim is involved,
Gotcha.
but there's always a statute, there's always a law that imposes a limit. in property insurance policies, there is always a provision called a suit limitation clause that does the same thing. It imposes a limit time-wise, and sometimes it's very short. It can be as a year, 365 days. If a dispute exists, if coverage is still at issue a year after a claim was made, or damage was known about, or damage occurred, you have to look at the policy language. If no lawsuit's filed, the policyholder is forever barred.
Wow.
So
they could,
be aware.
They could totally lose out on a year.
Totally
and one
lose
day.
out
Year and
because
one day.
of a technicality in the insurance contract. So another good reason to consult with lawyers early on is just understand the pitfalls, understand your rights,
Right.
so you can make a good decision on how you'd like to act.
Gotcha. And we've seen some of that where a building owner investigated something and saw the damage, put it on hold, got around to it finally, and a few years later, then all of a sudden they're out of luck.
They're out of luck. Courts enforce
Sad.
suit limitation clauses. If notice isn't given in a timely fashion and that delay causes harm or prejudice to an insurance company or someone else, it's difficult to prove, but if the insurance company can prove prejudice, you may lose the ability to make an otherwise valid claim.
Okay. So we've talked about, we've found the damage, we've called you, you've notified everybody, you've checked through the timing, and you've got us on this process. Okay, so it sounds like we're in good shape. What happens if the insurance company or even the contractor that we're talking to or some other party in that contract doesn't play along? What happens?
Well, I mean, if you're a property owner and you're in a situation where you're seeking compensation or seeking to recover against another party, an insurance company or perhaps a contractor or subcontractor who may have caused the issue, if you're involved in that type of situation, obviously it can be competitive, it can be adversarial. So obviously a solution to a problem is what property owners want. I have yet to meet a client who is interested in litigating for the sake of litigating. So the first thing you do is you see whether there are any non-adversarial ways to resolve their dispute. Informal discussions, mediation sessions, other ways to use alternative dispute resolution, arbitration. What is the least and most economical way to resolve a dispute? That's what I think a wise property owner does. If you run into contractors or insurance companies who you think are doing the wrong thing, then certainly you can avail yourself of the court system, arbitration provisions. That's obviously where someone like our firm can help, give you advice. Do you have a remedy in the court system? How long will it take? How efficient will it be? I think good legal advice takes all those things into account, so a property owner can make an informed decision at the end of the day. Is there a realistic positive recovery, or is this cost-benefit analysis on this not going to work out? That's what we endeavor to do for our clients.
Gotcha. Okay. Let's see how to, what are some good success stories, or maybe fun stories, or unique stories that you can share?
Well, I have a unique story. When I was a young lawyer, I worked for a firm in Seattle, Lee Smart, Cook, Martin, and Patterson. I actually defended cases and learned a whole lot. But when I was a young lawyer, there was a single-family residential dispute that involved the property owner versus our client, a company that would fertilize lawns. Long story short, the fertilizer was alleged to have killed the plaintiff's tree, a ginkgo tree. He was very attached to this ginkgo tree. And so...
did they have insurance for that?
Well, they did have insurance, or my client who was alleged to be at fault had insurance. And interestingly, the plaintiff in this case wasn't interested in money for the ginkgo tree. He wanted a new ginkgo tree and a letter of apology from the company's president. So I was assigned to that case midway, and it resulted in me not going to a settlement meeting or going to court. It involved me personally delivering this individual a new ginkgo tree and a letter of apology from the president of the company. So that was an interesting story.
Wow.
Success stories, I've been to condominium association meetings a year or two after a very hard-fought claim was litigated in court, where the board president returns to unit owners the full amount of the special assessments that they incurred to fix a building envelope because there had been a successful claim or pursuit against an insurance company. We've been involved in cases involving construction of the light rail station in Beacon Hill, massive engineering projects, all kind of interesting things. We love our clients. We like to help property owners, like to work with people like you. So I could go on and on. More time than we frankly have to tell the good stories.
So what is, so it's not about appearing in court and you know, filing a brief that turns your crank. What is it about this line of work that keeps you coming back every day?
It's the people. It's helping people solve problems. We think we do what we do very well, whether it's in court or not, but most of our clients are looking for solutions. If it has to be in court, so be it, but we enjoy helping people through creative methods figure out a problem and get back on the road with their life and what they'd rather do than frankly work with lawyers.
Perfect. All right, well, we'll wrap it up with you, Greg. Thank you for being in studio today. We're going to put all of Greg's contact information at the end, but if you've stayed with us this far, that means you liked what you're seeing. And so it would really be helpful to us if you'd share this, if you'd give us positive feedback, if you'd like us on all the social media areas, and that just helps us spread the word. So we appreciate your time today, and hopefully this video was useful. Thanks a lot.